A very good evening to all of you, especially those who were not able to join us in the afternoon when we had the joint session with my colleague, lawyer Gertrude Ama. But of course, the recording of what we did is available. So if you have the time, you can play back. So tonight, we propose to continue with our learning on, of course, revision of land law. But as far as the Land Act is concerned, I'll say our learning, because all of us are learning it together. It's a new law, and all of us need to learn it. So we'll be learning or be revising land law, and especially the Land Act 2020 Act 1036, against the backdrop of, I think, 5 questions I thought could guide us in exploring some of the things that we should stand ourselves in readiness to be able to speak to or write about, as far as land law or movable property is concerned. Should there be questions and things like that? So in that respect, I think the questions center on you being aware of how the customary land law interests, for example, have been affected by the new law. And yesterday, we made an effort to discuss that within the context of our very good friend, Sir Justice Dennis J, in his very useful illuminating lecture he gave as his inaugural lecture at the Ghana Academy of Arts and Sciences in April 2021. And again, part of the question, or the other question also relate to we being able to, for example, discuss the extent to which the Land Registry Act and the Land Registration Law, which have all been repealed by Act 992, if, of course, there were inadequacies, there were some shortcomings or some dissatisfaction regarding that law, as far as land transactions and land administration in the country is concerned. And that is why same have been repealed. So our question is, if that is so, in what respect do we see Act 1036, that is the Land Act 2020, as having overcome or provided panacea or solution to some of the problems or shortcomings of the old law with respect to Land Registry Act and more importantly, Land Title Registration Law? So there was a question on that. And I think another question also relates to an invitation for us to think about the ways in which the law relating to exercise of eminent domain by the state, that is compulsory acquisition, for example, has been improved by Act 992. We see any improvements in this particular area of land law. Of course, we are aware of Article 20 of the Constitution and the State Lands Act, Act 125 and all that, which work together to enable the state to compulsorily acquire land for public purpose and all that. There were some problems, as we have seen in a number of cases, including the Okujetu, Athena Blackwire, and then the late Obichebi Lamte case and all that. But fundamental question of interest is, can we say that the new law, Act 1036, has improved or addressed perceived or actual flaws of the old law? So those are some of the general issues. And finally, I also indicated in the questions, or like I should suggest that it is pertinent for us to know like the new things which the Act 992 has, for example, brought onto the table. So if you were invited to make a presentation or a memo or whatever, telling either foreign investors or telling some group of people or whatever about new developments in the law. And then finally, I also remember saying that we need to think about problems which were associated with land transaction prior to the adoption of Act 1036, especially problem of fraudulent transactions in land acquisition and land sales, the problem of like the multiple sale of land and all that. So how are those problems, for example, contained or intended to be contained by the new Land Act? And I think I also advised you yesterday that it is a very useful exercise to try and familiarize yourself with the entire Act 1036. And if you were wondering how to do it, just make an effort to read 15 sessions a day. In addition to that, you should also read the interpretation session, I think session 181 or so, just for purposes of the multiple choice. Now we'll continue with our discussion, but as a teaser, and I know students, especially some students, lack what we call like the self-motivation to be able to learn certain things on their own, and they need to be facilitated or assisted. And that is why I have volunteered to be doing this with you. Otherwise, most of the things that I'm saying, they are in the books. You can read them yourselves. But some students are saying that they need to get somebody to at least give them a bit of explanation so that when they read what is in the book, it will sink quickly. And if you are like that, that is fine. A good number of us are like that, so there's no problem. So before we move on to continue with the changes which have been made by Act 1036, as we sought to do, so we continue from the restriction acquisition line by the non-citizen of Ghana. Before we do that, as a footnote and as a teaser, in anticipation of maybe one or two questions as far as multiple choice is concerned, I would like you to take your Act 1036, and then let's look at section 281 and just get ourselves familiarized with something. So approved plan, as far as the Land Act is concerned, has a particular meaning. So when approved plan is mentioned, it means a plan prepared by an official surveyor or licensed surveyor who shows the boundaries of land with accuracy and gives an exact measurement by which the boundaries may be demarcated or redemarcated on the ground and approved by the Director of Survey and Mapping Division. So this is a very unique meaning. And so when, for purposes of a land law, if we talk about approved plan, approved plan. We are talking about a plan which has been approved by the Director of Survey and Mapping Disposition, and not any other site plan. So let's keep that in mind. What is the meaning of assignment? Assignment is explained as the transfer of the unexpired portion of term or interest created by a lease. So in land law, if you see assignment, this is what the lawmaker want it to be understood as, that the transfer of the unexpired portion of term or interest created by a lease. And this is a very restrictive meaning in the sense that so assignment cannot be in respect of any interest other than a sublease or sublease as it were. So let's keep that in mind for purposes of land law. And then when we say like the caveats with respect to title registration or with respect to land interest or title perfection, it has a unique meaning, and it means a formal request that prohibits the registration of a disposition and the making of an entry on the land certificate or register to the extent specified in the certificate or register. So here, you notice that the caveat here means different from caveat in respect of letters of administration, because when you are doing the estate, right, letters of administration, we also have like a caveat there, where or probate, where you think that the court should not grant an application for LA or probate, you enter a caveat. So that one is there, but here we are not talking about that. We are talking about the caveat where an application is made to have an interest registered on a land certificate, or what used to be called like the land title certificate. Yeah, so that is the meaning. Then what about a clan? When we say a clan, what does it mean? Under Act 1036, still under Section 281, clan include a group of families that can be traced to a common ancestor and includes a collection of clans. So, you know, you have multiple choice. You have to know that clan include group of that can be traced to a common ancestor. So that is the catchword. Then what is a clan land? A clan land, and this is a new terminology, because if you look like the old law, none of the repealed act, for example, had any term or phrase as a clan land. So this is a new thing. We rather had what we call like the stool land, if you like, a family land. So clan land, according to Section 281, includes land, the allodial title to which is held by a clan or collection of clans for the benefit of the members of that clan or clans in accordance with customary law, and includes land in parts of the country where a clan or collection of clan is headed by a Tindana. So we have the Tindana dome, like in some places, like in the north. The Tindana is supposed to be what you call like the spiritual head or the owner of land. So commercial property, of course, that is quite straightforward. It means for building or land that can be used for commercial purpose. That is straightforward. Commission, there's no dispute as to the meaning. It means lands commission. And then common land. Common land means land set aside by a community for common use. Under Section 19, if you remember Section 19, we were talking about how the holder of the allodial title, yesterday we talked about that, how a holder of the allodial title, for example, could interfere, right? Could interfere with the usufructuary interest insofar as same is required for the common use or common purpose, like typically for either expansion of the settlement or township or some infrastructure. Section 19 said that in that respect, you can interfere with the usufructuary interest, especially like in the community where members of the family or the stool that has allodia, they decide to do some farming and all that. And in the course of time, population increase and they would like to expand the town. How do you manage that? And I want you to pay attention to section 19 because section 19 is a very new thing which is being introduced to our law. And when you are asked to talk about how customary land law or customary law interests in land has been affected by the Land Act, I think you will not you will not have finished doing justice to the question if, for example, you don't address what we talked about last time, like the fact that the stool can interfere with someone's infatuatory interest where it is needed for the common purpose, as it were. Then let's move on. So community, when we say community, what does it mean? And community for purposes of land law means, and then to be provided, a group of families and individuals living in a territorial area and that has common interests in areas of habitation, agriculture, communal land use, and protection of land, whether cultivated or lying fallow, forests, places of cultural importance, pastures, water sources in areas for expansion. So that is the statutory meaning of community for purposes of a land in Ghana. Then when we say like the conveyance, we have to know what it includes because multiple choice, if the person wanted to just be, just worry you a little bit, they can just say the conveyance under the Land Act or conveyance for purposes of a land law in Ghana includes A. Then you provide the list there. So we have to know that it includes a document in writing by which an interest in land is transferred, an oral grant under customary law that is duly recorded in accordance with this act, a lease, disclaimer, release, and any other assurance of property or of an interest in property by an instrument except a will. So we could go back to the simple understanding in fact that conveyance means, apart from will, any instrument affecting an interest in land or carrying, no, like, sorry, not affecting, any instrument transferring an interest in land, that, because if you look at the list over there, that is what they all seek to do. The only exception is a will. So a will is not a conveyance. Director of Land Registration Division means director responsible for land registration, appointed under the Lands Commission at 2008 at 767. And then the disposition means, now yesterday, just before I move on, you remember we also talk about the list of legislation which has been repealed. Now, a list of legislation which have been repealed, and we did not mention the Lands Commission Act is still in force. The Lands Commission Act sets up like the Lands Commission is still in force, and so it is not repealed. So, because if you look at the section 282, is not one of the repealed. Is not one of the repealed provisions, so it's still very much in force. So let's keep that in mind. Then if we talk about disposition, what is the meaning of disposition? Any act by a proprietor of land or of an interest in land by which the rights of the proprietor in over the land are transferred during the lifetime of that proprietor. So disposition, in a sense, refers to inter vivos land transaction and not testamentary like the ones which are made in will, because that is the meaning as we have just quoted from section 281. Disturbance includes the inconvenience suffered by an occupier of land who has to relocate as a result of compulsory acquisition or temporary occupation of land by the state. So if you are discussing compulsory acquisition and we talk about like the disturbance, any inconvenience which the person who will have to yield up possession of his land because it is needed by the state to endure, that is what it means. And all those things will definitely be factored into in determining the quantum of the compensation which is to be given to that person. And I referred you to the provisions that you need to pay attention to as far as compulsory acquisition and determination of the compensation are concerned. Easement. Yeah, what is the meaning of easement? According to Act 1036, Section 281, easement means a right under the rules of common law attached to land and which allows the proprietor of land to which the right is attached. So before I even continue, let me remind you that easement is a creature of common law. It's not a creature of customary law. So in case there's just any red herring to distract you, when you hear easement, you know that it's an interest in land which is known or created by a common law and not customary law. So easement means a right under the rules of common law attached to land and which allows the proprietor of the land to which the right is attached to use another land in a particular manner or restrict the use of the land to a particular extent, but does not include any right capable of existing as profit or restrictive covenant. So profit, you're referring to like profit upfront. And so you know easement, a typical example is the right of what? Access. The right of access, as it were. But restrictive covenant is not treated as an easement. So let's keep that in mind. So let's say that if you have, let me give you an example in case you've forgotten. Let's say that your land is at Black Area, right? Black Area A. And before you can get to Black Area A or Black Acre A, you need to pass through Black Acre B. And you cannot get to Black Acre A, which is your land, without passing to Black Acre B. So you are right to be able to pass through Black Acre B in order to reach your land, Black Acre A, which is recognized by the common law, is the easement that we are talking about. Of course, then we also have encumbrance. When we say encumbrance, it includes a legal or equitable mortgage, right? A legal or equitable mortgage, that is like a charge, a trust for securing money, a lien, and a charge of a capital or annual sum. Yeah, so when we say legal or equitable mortgage, we know what we mean under the mortgages decree, which we mentioned yesterday, and that is still very much in force. There's not been a repeal. And then a trust for securing money. If you've created like a trust in respect of a property, insofar as the owner of the property, for example, has not finished paying for a certain loan, so long as the loan remains unpaid, then the trust, for example, is there. So that is also a form of encumbrance because the property is not free. There's a certain claim on it. That claim on it is what we call like the encumbrance, and it may arise in a number of ways. Then we also have like a lien. We know what the lien is already. Yeah, essential particulars include the name of the beneficiary, age of the beneficiary, certificate of registration, and registered trustees. So this will definitely relate to maybe a trust or acquiring a property for an infant, in which, because the law, and we noted the other day that under this law, if a property had previously been acquired in the name of an infant, then if you look at the transitional provision, right? If we look at the transitional provision, as we saw yesterday, especially section 283. Section 283, subsection 3 says that within 1 year after coming into force of this act, that is Act 1036, a person who has registered a land in the name of an infant shall ensure that that person registered the land in the name of an adult as a proprietor in trust for that benefit. Yeah, so that is what the essential particulars that we just quoted from section 218 is alluding to. Then family, what is the meaning of family? According to Act 1036, family means a group of persons who trace their ancestry from a common lineage and who at customary law are recognized as a land-owning group. So this is very important. So if the particular group, even if they trace their ancestry from a common lineage, but at common law, they are not recognized as a land-owning group. It's not a family. And this has a pertinent implication for, let's say, foreigners, right? So let's take our brethren from Burkina Faso, the Musi people and all that. They can trace their ancestry to a common lineage, but as far as the customary law in Ghana is concerned, is not what we call a land-owning group, because they don't have land in Ghana. If they have land at all, the land that they have is a land that individually, maybe somebody acquired by way of purchase or gifts, and is not a family land as understood in customary law. So the definition of family for land law, as far as Act 1036 is concerned, is quite interesting. So we have to keep that in mind. So therefore, what is a family land? We know what the family is now. So what is a family land? A family land means land, the allodial title, to which is held by a family for the benefit of the members of that family in accordance with customary law. So land, the allodial title to which is held by a family for the benefit of the members of that family in accordance with customary law. So therefore, talking about the family land, the allodial title to that should be held by the family, and the members are supposed to be like the beneficiary. And for that matter, they can have the usufructuary interest out of that. Grantee simply means that a person who takes or receives an interest and an instrument creating an interest in land or transfer an interest in land. So if you are the beneficiary, then you are the grantee. And if you are the one making the interest available to another person per the particular instrument that you have executed, then you are the grantor. Yeah, right. So let's keep that in mind. And that is why grantor is defined specifically as grantor includes a person who conveys, mortgages, charges, or otherwise demands land or interest in land. So let's suppose that your objectives, we say that grantor for purposes of land law includes a person A, who conveys, B, mortgages, C, charges, D, all of the above, and maybe like the E, none of the above. You should know the correct answer is what is all of the above. So you have to, that is the more reason why I'm just at pains to walk you through something which is rather obvious, but for good reason. You need to be prompted to address your mind. Who knows? Then when we say like a group, what is the meaning of a group for purposes of land law? Group means a body of person whose lineage can be traced from a stool or skin or clan or family, such as quarters and gates. Indigene, who is an indigene? Indigene means a person who, in accordance with customary law, A, hails from a community or settlement and is subject of a stool, is a subject of a stool or skin, or member of a clan or family which holds allodial title to land. So that is an indigene. That is an indigene as opposed to a stranger, if you like. So an indigene must hail from the community or settlement and must be a subject of either a stool or skin, or member of a clan or family which holds allodial title to land. So there's that need for some nexus or some relationship with the allodia. So you cannot call yourself an indigene if you cannot link yourself to either a stool or skin or family or clan which has the allodia to a particular stretch of land. Infant, we've already noted that for purposes of a land law in Ghana now, infant means a person who has not attained the age of 18 years. And of course, last year, a problem-based question on contracts centered around capacity and looking at the marking scheme or discussion among examiners, there was that debate as to whether the age should just be recognized as the old common law of 21 years or the 18 years and so on and so forth. But at least now looking at the Act 1036, which is a law which was made in less than a year, it reinforces the impression or the assumption which some scholars have made that capacity contract should even be understood as being 18 years. Because if you look at the Land Act 1036, it says 18 years. If you look at the Companies Act of 2019, Act 992, it also says that an infant is 18 years. So all these legislation are barely a year or a year and a half. And so that is reinforcing this, that maybe the capacity to do any transaction probably in Ghana is 18 years. Instrument. What is an instrument for purposes of like the land law? Instrument means any writing which affects land situate in this country, including a judge's certificate and a memorandum of deposit of title deeds. So for purposes of land law in Ghana, right, if you are talking about instruments, if it does not affect a land which is situated in Ghana, it's not an instrument. Therefore, if you bring maybe some documents from maybe Benin or from the US concerning land over there, as far as Act 1036 is concerned, it is not an instrument because the definition is quite precise and stipulative that instrument means any writing which affects land situate in this country. And this country means Ghana, including a judge's certificate and memorandum of deposit of title deeds. When we say a judge's certificate, you may not know what we are talking about. But the judge's certificate, we are referring to, for example, either a judgment, right? Making declaration of title in favor of someone. So that is a judge's certificate. Or where there has been an auction, there has been an auction of a landed property or a house, and then certificate of purchase will have to be issued. And that is also another example of a judge's certificate, which can also count as an instrument so far as it relates to a land in Ghana. So let's keep that in mind. Then interest in land, when we say an interest in land, it means any right or interest in or over land which is registrable under the Act. So they're very straightforward. Yeah, so judge's certificate has been explained as a certificate of purchase of land which is sold in execution of a judgment and signed by a judge or magistrate and a certificate of title signed by a judge or magistrate in pursuant to the court order. So two things, as I told you, either there has been an auction of a land or landed property. You bought it, you need to get what do you call it, the certificate of purchase, and that will be like the judge's certificate confirming that yes, you have actually purchased this land after free and open auction. Or there might have been a litigation and it was in respect of a declaration of title to land. And the court actually declared that you are the owner or you have title. So that is also judge's certificate. And to all intents and purposes, it can be an instrument. So I often tell people that if, for example, and this is a free legal advice, if you buy land, right, and the land that you bought, the vendor does not have like proper documentation, like a registered lease and so on and so forth. But you want to assure yourself that you have some higher guarantee of your title, and the money that you have put in the transaction should not become wasted. One of the smart ways which you can use is to go to your lawyers, let them issue a writ and make a case concerning your land and look for declaration of title. So you go through the judicial process, you succeed and you definitely get a judgment. You get a judgment which will be a declaration of title in your favor. Now, not until that judgment has been overturned or set aside, to all intents and purposes, that is a judge's certificate and is sort of give you some proper legal documentation for the interest that you have in that land. Yeah. But let's move on. When we say land, how is land defined? Because so far we haven't talked about definition of land. According to section 281, land includes, and look at what it's saying. It does not say mean, it says includes. And you have noted that in this section 281 that we'll be looking at, the definition are put in one of two ways. Sometimes it will say that it means this. Another time it will say that it includes this. When it says that it means this, what that means is that that definition is exclusive, conclusive, and is final. If it's like all or nothing, it is either what it has stated or it is not that which is being defined. But when we say that it includes, what that means is that there are some other possibilities which have not been stated, and then we can use, and that is where when we're discussing Ghana legal system and legal method this afternoon, we talk about the use them generis rule, that where you have like a list and it has got like what you call like a general word ending. Then you control the meaning of that general word by the particular genus or class which the preceding words actually portray. So in the same way, the other things which are not stated, you can work them out using what has been stated. So let's keep that in mind. So land, let's come to meaning. What is land? Land includes the solid surface of the earth, trees, plant, crops, and other vegetation. A part of the earth surface covered by water, any house, building, or structure whatsoever, and any interest or right in, to or over immovable property. Good. We need to also keep this definition of land in our mind. And I want you to also pay attention to the fact that an interest or right in over any movable property is land. So let's keep that in mind, of course, and it's quite elementary. So we are not talking only about like the physical land. The physical land, obviously, the various manifestations of it are all land, but the intrinsic aspect of it is also land. Intrinsic aspect in the sense that the interests or the rights which are held in the land, which we cannot see with our eye. Somebody will say that I have a lease, I have a sub-lease, and so on and so forth. All these things are the intrinsic, intangible. You cannot see with your eyes, but yet they are considered as a part of lands with their land. When we say land certificate means a certificate duly issued under section 125. So land certificate has got a very stipulative meaning. And I'm sure now you have read section 125 as it were. So so look at section 125. That is a land certificate. That the land registrar shall, on registration of person as proprietor of land or holder of interest in land, issue a land certificate. Okay, so let's move on. So who is a lessee? Lessee is a person. It includes original. Oh, sorry, I've skipped one. Land owning group means a stool or skin, clan or family, or other collection of individuals that holds title to land. So that is straightforward. And land register means the register of proprietors of land and interest in land kept in accordance with this act. So that is a land register. Then lands for land register and lands commission are quite obvious. So lease, lessee includes an original or derivative sub-lessee and those deriving title under the lease. So anybody in whose favor a lease has been made is a lessee. And also, if you also have the lease after a sub-lease has been carved out of an existing lease, and all that, you're also a lessee for purposes of the law. And the grantor of that is a lessor. Now, what is a license? License, remember, land law, we discuss license after talking about easement, profit apron, and all that. So license means a permission other than easement or profit given by, if I say profit, I'm referring to profit apron. Profit apron. For example, you are right to go and take the fructus, right? To fructus maybe from the land, or to pluck a fruit or something from other land. That is a part of like the profit apron. Yeah, so license means a permission other than easement or profit given by proprietor of land, of an interest in land, which allows the person granted the permission to do certain acts in relation to the land, which will otherwise be a trespass. Yeah, so quite apart from easement, profit, those are in their own category. Apart from that, if the proprietor of land or interest in land gives you permission to go to the land and do anything on that land, and if it had not been for that permission, what you are doing on the land will be considered as a trespass, then that is a license. So it is a license which protects you from being liable for trespass, meaning that if it had not been for the license, you are being a trespasser on the land. And as I said, we are not talking about easement, we are not talking about profit, because those things have been conferred by different legal principles at common law. Local plan, when we say local plan under Act 1036, it means a detailed plan which proposes a dimensionally accurate disposition of parcels of land by function and purpose, meet the present and future identified community needs within the time frame for which the plan is valid. Now, this is also a very new thing which is being brought to our law. So let's pay attention to the wording. Local plan means a detailed plan which proposes a dimensionally accurate disposition of parcels of land by function and purpose to meet the present and future identified community needs within the time frame for which the plan is valid. So let's keep that in mind. Market value means the sum of money which may be realized if the land were sold on the open market by a willing seller and bought by a willing purchaser. So the idea of market value is important when, for example, you are discussing how to compute compensation to be paid upon compulsory acquisition, because you may need to find out what is like the market value of the land which is being compulsorily acquired, and all those things will form an important information or context in being able to determine the most fair and realistic compensation to be given to the person whose land is being compulsorily acquired, so that the person is not overcompensated or undercompensated. And that is why the ideas of market value and all that are very important. And those of you who have read the position that the provisions that we ask you to read, especially from section 233, from section 233 up to 267, governing compulsory acquisition, you have come across the need of the concept of a market value in trying to work out the compensation which should be paid to a person whose land is being taken. Good. And then again, we'll be finishing very soon, and then we come back to our main discussion. As I said, if you don't do that, some of you will not bother to read it. And okay, then we also have like the mineral. When we say a mineral, what is it? Mineral means a substance in solid or liquid form that occurs naturally in and under or upon any land formed by or subject to geological process. So what this means is that an oil is a mineral. So oil is a mineral because we are told that a substance in solid or liquid form. Mortgage has a meaning under Mortgages Act, and we've seen that yesterday. Personal representative has a meaning assigned to it in section 108. When we say personal representative, we're referring to someone who has been given the power, the letters of administration, or who has been given like the probates to administer the estate of someone. When we say plan, what does it mean? Plan includes a map depicting in the manner and to the standard of accuracy defined by the Director of Survey and Mapping Division, the relative position, beacons, boundaries, and dimensions of one or more parcels of land as surveyed by an official surveyor or licensed surveyor, and which have been prepared by that surveyor as having become compiled from official records of survey. So that is what we mean by a plan. And we often talk about like the site plan. So this is the stipulative, the meaning. Then profit. What is profit? Profit means the right at common law to go on the land of another person, to take a particular type of objects from that land, whether part of the soil or product of the soil. So at common law, your entitlement, you are right to be able to go to land of another person and take something from there. And you will not be accused of, if you like, having trespass or anything, because it is a law which is saying that you can do that. That is the profit. Or the old long form is the profit upon. Profit upon. Proprietor means in relation to any land or interest in land, the person named in the land register as the proprietor of that land or interest in land, and also means the donee of a power to appoint or dispose of the land or interest in land. So that is a proprietor. And for purposes of land law, when we say public body, any organ of state institution, and then the MDS and all that. And purchaser, we know who a purchaser is. A purchaser, no, it's not, we don't know who a purchaser is. A purchaser has been given a very distinct definition. So let us pay attention to that. Purchaser means a person who, in good faith, that is with emphasis with good faith, acquires land or an interest in land for valuable consideration, and includes a lessee or other person who, for valuable consideration, acquires an interest in property, and where the context so requires, includes an intending purchaser. Okay, so that is it. You acquired the land in good faith, and then you paid valuable consideration. Or you are someone who intends to do that. You are considered a purchaser. Registration district, I mean, just equivalent of what we know from a PNS 152 that includes a district declared for purposes of registration of land, including a registration session. So that is very straightforward. Let us finish. Yeah, rent. When we say rent, includes any periodic payment in money or money's worth made, reserved, or charged upon land. So that is a rent. And scheduled lands means land proposed for acquisition by the state. So this is another thing to keep in mind. Scheduled land means the following: A, land proposed for acquisition by district assembly, land proposed for acquisition by a chief, land proposed for acquisition by a family, land proposed for acquisition for a state. So like, this is a simple thing. If you haven't, for example, read, you have gotten it wrong, but it's not anything which is difficult. So for purposes of the Land Act, when we say scheduled land or scheduled land, it means land proposed for acquisition by the state. So which means like a candidate for compulsory acquisition, isn't it? Yeah. Site plan. Site plan means a plan that shows the boundary of land with accuracy and giving exact measurements by which the boundaries may be demarcated on the ground, and that is made in conformity with the result of a survey carried out by an official surveyor or licensed surveyor, and that has been certified by that surveyor and approved by the director of the surveyor and mapping division. So this is very important. So now when we talk about like a site plan, you don't just parade anything as a site plan in trying to prove the identity of a land to which you are laying a claim to. It must be a plan which has been approved by the director of survey and mapping division. Otherwise, it's not like a valid site plan. And this is making a lot of difference when it comes to land litigation in the country. And then the lawyers will tell you more about that. When we say a stool includes a skin, as well as any person or body of person having control over skin or community land as a representative of the particular community. So that is a stool. And a stool land obviously includes land or interest in or right over land controlled by stool or skin or the head of a particular community for the benefit of the subjects of that stool, skin, or members of that community. And a surveyor includes an official land surveyor or a licensed surveyor authorized by the Lands Commission to perform functions under the Act. Tacking, what is tacking? Tacking means the process. Of course, when we are dealing with the mortgages and those kind of collateralization, that's what we come across that. But in this Act too, it has been used. So tacking means the process by which a loan advanced subsequently to the creation of a second mortgage of a parcel may be secured on the first mortgage of that parcel and takes priority over the second mortgage. Yeah, so you have created, I think there's even like a whole provision on tacking. I think session number, who can tell us the session? Provision on tacking I came across in my reading. Session number what? And see if anybody has it. Oh, You're not telling me the session is happening. There's a provision on it. Somebody should tell me so that we just go there. Session what? It means you are not reading. I ask you to read the law. If you're reading it, you'll be able to tell me that go to session number this. There's a provision on tacking. And what is the session on tacking? Anybody? Oh, you're disappointing me. What is the provision on tacking? What section of Act 1036? Anybody, you can raise up your hand if you, or you can just write it in the chat. There's a provision on tacking in Act 1036. What section is that? Are we together? Yes. Number 72. What is it? Yes, your hand is up. You can speak. Was it accidental? Okay, since you don't remember when I come across it, I will let you have it again. Yeah, so you have like a mortgage in respect of, you have like the first mortgage, then you have like the second mortgage for which like you take another loan. So there'll be issue as to like the priority. So that is what the tacking concept is referring to. And that is why it is explained as meaning the process by which a loan advanced subsequently to the creation of a second mortgage of a parcel may be secured on the first mortgage of that parcel and takes priority over the second mortgage. Ordinarily speaking, if you have like the first mortgage and the second mortgage, yes, the first mortgage will have priority over the second mortgage, and second mortgage will have priority over any other thing. But the tacking process can allow the later in time loan after the second mortgage to take priority over the second mortgage. As somebody found the provision, okay, session 151. Thank you, Fufu. Session 151. 151. Further advances. Okay. A mortgage of land of interest in land register that may make further advances in priority to any subsequent mortgage noted in the land register. Okay, that is fine. So section 151 addresses the tacking process. But there's a provision. There's a provision in which the word tacking is actually used. Okay, right, the 151 subsection 3, right. Yeah, all right, okay, that is fine. Okay, so let's quickly, we are almost done with the interpretation session. And Tindana, when we say like the Tindana, Tindana means it has to do with the Tindana dome like in the north, means the descendant of the first settler, who is a custodian of land for a group of clans tracing the ancestry to the first settler. So when we mention like the Tindana, we don't have Tindana in the south. So you have to note that. So for example, if they wanted to trick you, you could also bring something question like that. Tindana is some of the communities in the north, not even all of them. So over there, the thinking is that the first person to settle there, he was called like the spiritual head and then the owner of the land. And later on, when even like the chief and his people are there, the chief does not have control over the land. It is like the Tindana, because he was like the first person to have settled on that parcel of land. Traditional area has a meaning assigned to it in the Chieftaincy Act. Of course, transfer means is quite means the passing of title to or interest in or rights over land or by an act of the parties, and not by operation of law. Transmission. So there are two things. Transfer is different from transmission. Transmission refers to transfer of land or an interest in land from one person to another by operation of law. When we say like by operation of law, for example, adverse possession, right? The squatter or the trespasser acquires a title by adverse possession, and it is the operation of law which has made that possible, and it's not like a normal transfer of what by the original proprietor of the interest in the land. So that is the kind of thing we are talking about. Or death. Yeah, so that is another one. Bankruptcy, insolvency, otherwise, by virtue of appointment or succession of any office, and by compulsory acquisition of land. All those things are considered as the transmission. So we can say that transmission of land means the following. Then they put the list there. A, transfer of land or interest in land from one person to another by operation of law or death. Oh no, I mean by A, by operation of law, full stop. And then they repeat the same thing by death. And then C, bankruptcy, insolvency. And then maybe like D, they will say that passing of title or interest by an act of parties, not by operation of law. And then maybe like E, all of the above except D. Then you have to tell us what the correct answer is. Vesting order. So that is the last one for us. Vesting order means an order by a court of competent jurisdiction transferring legal title in absence of a legal conveyance. Okay, so legal conveyance is where you've actually made an instrument transferring an interest and all that. But quite apart from that, the court can also make like a vesting order. Somebody has asked a question, say from the definition, it looks like the Tindana is a general definition than anything that has to do with a particular area. First settler. Yes, that is true, but don't forget that yesterday, when we were discussing the interest in land, especially the customary land law one, we said that the incidents and mode of acquisition and all that are still subject to what the customary law position say, isn't it? If you look at section 8, right? Section 8. So it still refers to customary law. And if you go back to customary law and history, the Tindanas are not in the south. So if I say like the south, I'm talking about like the from the middle belt downwards and to the coastal area and all that. But the Tindanas are usually in the original northern and the upper region. That is where you find some. Yeah, so that is that. Okay, so having finished this footnote remark, because I promised that we make some progress with our discussion, let me do that. But before coming back to substantive presentation, I would like to find out if you have anything, just put it in the chat so that we can look at it. Now, yesterday, I made the point that we need to be aware of the changes which have been made by Act 1036 to our land law, and we look at some of them. We look at we started from like the customary land law interest, customary tenancies, and all that. We discussed that, and we were to look at restoration on acquisition of land by non-citizens of Ghana. Now, I think then we ended the class. So we propose to spend the next 40 minutes doing that before we end. But if you want to go to bed, you can go to bed, and later if you want to listen, you can listen. That is fine. Now, if you remember from the Constitution and also from your land law in general, in the 1969 Constitution, there was a provision, which, of course, and rightly so, as Sir Dennis has put it, the expropriation provision. Expropriation provision in the sense that it's like the Republic of Ghana compulsorily took over property of foreigners in a certain way by converting freehold interests, which non-citizen, non-Ghanaians had in land in Ghana into leasehold of 50 years. So if you have like the freehold, meaning that you have more or less like unlimited quantum of interest in land, by the 1969 Constitution, same had automatically been converted into a leasehold of 50 years. And all leases, which also exceeded 50 years, were also converted to 50 years. It was abridged to 50 years. And all these took effect from 22nd August 1969. So you, depending upon the particular list you have, you calculate using the cutoff date or the starting date as 22nd August 1969 to know when the particular list will end. Yeah, so that is the one thing that we should keep in mind. And of course, for very first time in a more extensive language, who a citizen is was also well spelled out, especially of natural persons, but artificial persons, the Constitution was quite silent on that. And for that matter, as Dennis makes the point that the courts interpreted the company and partnership with interest of any kind by a non-citizen of Ghana as a non-citizen. In other words, not artificial persons were also treated as what? As non-citizen. They were put in the same category as non-Ghanaians. And for that matter, artificial persons like the companies incorporated, the private partnership and all that were put in the same category as non-Ghanaians. And that meant that they could not have an interest in land of more than 50 years at any one time. So that is what we should keep in mind. Now, if you look at the Land Act, especially section 10, right? If you look at the section 10.1, a point is made, and I quote that, a person shall not create an interest in or right over land in Ghana, which vests in another person who is not a citizen of Ghana, a freehold interest howsoever described. Okay, that is pretty straightforward, but that also applies to Ghanaian company. That also applies to a company like, because artificial person, so to speak. But if you look further, you notice that where you have like a company or anybody corporate in which the shares in it or the ownership in it, you don't have maybe like 40% or more being held by Ghanaians, then that will be treated. So what is important now is that if you look at the new law, you notice that there is an attempt to try and bring sanity into whether a company will be treated as a Ghanaian, and for that matter, the restriction of the interest which it can have. But I'd like us to look at the provisions themselves, and that is very helpful. So let's go back to section 10, subsection 2. An agreement or deed or interest of whatever nature which seeks contrary to subsection 1 to confer on a person who is not a citizen of Ghana a freehold interest or right over the land is void. Yeah, so automatically a non-Ghanaian who has been given a freehold interest is automatically void. And this is also in the Constitution, so it's just reenacting the constitutional provision that we know. And we've already talked about the fact that if you had like a freehold interest, just as the 1969 Constitution sought to do that, it had been reduced to 50 years, starting from 22nd August 1969. That same thing has also been retained by our law. So let us keep note of that. And again, if we question will be like, who has a reversionary interest? If, for example, you have converted a 50-year-old, you've converted like a 99-year-old lease to 50 years. Okay, so after the expiry of the 50 years, who will become beneficiary of that land? Now, the freehold reversionary, that is after the exhaustion of the particular duration of a leasehold, which has been allowed now, which is like the 50 years, the land will go back to vest in the president of Ghana in trust and on behalf of the people of Ghana. And those are the lands which, for example, the Lands Commission from time to time try to find a way and say that there's a land available there, they can parcel out or they can sell and things like that. Yeah, so and the restrictions we've been talking about with respect to a non-Ghanaian also applies to like in the case of like a marriage. So if you look at the subsection 10.9, that the restrictions in subsection 1, 2, 3, and 7 on the interest that a person who is not a citizen of Ghana may acquire in land shall not be affected by marriage of that person to a citizen of Ghana or by entry of that person into a partnership with a citizen of Ghana. So it is not the case that you are a non-Ghanaian, you married a Ghanaian, and because you married a Ghanaian, then you are excused from the restriction which says that a non-Ghanaian cannot have a freehold interest, or a non-Ghanaian cannot have like a lease for more than 50 years at one particular time. So the marrying a Ghanaian will not change that. And again, entering into partnership, of course, we call it incorporated private partnership, because that is what we have now. There's nothing like partnership simplicity. So having had the incorporated partnership with a citizen of Ghana would also not mean that you are still excused from this restriction. You are still bound by those restrictions. Now, if we look at subsection 10, it makes the point that for purposes of this session, a company or corporate body is not a citizen if more than 40% of the equity shareholding ownership is held by non-citizen. So if you want to know unlike the old law, in which we did not have clarity concerning whether an artificial body like company, incorporated private partnership is a citizen or not citizen, for purposes of knowing whether the rule against the holding of the freehold interest by non-citizen applies to the company or not. That was quite vague, but at least subsection 10 now brings clarity that if we want to know whether, for purposes of the restrictions which are imposed on the non-Ghanaians, it applies to company or not, we need to first of all ask ourselves, in terms of the equity shareholding or the ownership, how much is held by Ghanaians? If more than 40% of the equity shareholding ownership is held by the non-citizen, that is the foreigners, then the company, for purposes of this provision, is not Ghanaian. It will be treated as a non-citizen and to be subject to all the restrictions, meaning that the company cannot get a lease of more than 50 years at a time. Neither can it get a freehold like interest as it was. So let's keep that in mind. And if we look at the Ghana Investment Promotion Act, it provides that a body corporate, whether corporate or incorporated, whose majority capital or financial interest is owned by a citizen of Ghana, is a citizen of Ghana. But that does not mean that just any majority, because if you look at the Land Act, the Land Act has given some prescription, and what we have seen from 60 is quite obvious. So there's some mathematical predictability here that if more than 40% shareholding is held by non-citizens, then it's not a Ghanaian company. So the opposite is true, that for it to be qualified as a Ghanaian company, then 60% or more of the shares should be held by Ghanaians, and then it will qualify as such. Now, the other thing that we need to draw our attention to, maybe for purposes of just some of the new development, is about accountability of traditional leaders like chiefs, Tindana, clan heads, and family heads, who are in charge of the management of stool or skin or clan or family land. So yesterday, I asked you to read the Customary Land Law, Customary Land Management. That is chapter 1 of part 2, and just a few provisions from section 13. From section 13 to I think section 20 to section 20, no, to 30, 31. Yeah, that is what. No, I think no, not that. Sorry, to section 22. Just from 13 to 22, it contains the detailed rules on what is expected when it comes to customary land management, how we actually manage some of these two land, skin lands, family land, clan lands, and so on. So that is very important. And the point as made by Sedin is that not until this law, Act 1036, was passed, if we look at all the other laws, there was no express law that chiefs should be made or chiefs are accountable in respect of skin lands and that they manage. But maybe the qualification I'll add to the point he's making is that, remember PNDC law 1, I think PNDC law 112 or so, that is the head of family accountability law, a head of family accountability law. And of course, if you're head of family and the family has like the land, then the accountability which you're supposed to render will extend to that. So that one is the exception. But he's right. So Dennis is quite right that as far as chiefs were concerned, there was no requirement that they should be held, if you like, accountable regarding their management of stool or skin land. Of course, if you look at the directive principles of state policy, Article 36(8), it requires fiduciaries who are charged with management of stool or skin land to be accountable to their subjects. And again, if we read that provision, that they are supposed to act with fairness, impartiality, and transparency in every decision they take on management of land under their control. So that is fine. And where they take this accountability for granted, there are consequences. So if you look at section 13.2, right? If you look at section 13.2, a chief, Tindana, clan head, family head, or any other authority who is in charge of the management of a stool land is a fiduciary. And this is a very serious thing. It's a fiduciary charged with obligation to discharge the management function for the benefit of the stool or skin or clan or family concerned, and is accountable as a fiduciary. So all the things that we know concerning fiduciaries when it comes to discussion of directors or even like the agents and so on, mutatis mutandis, it also applies to chiefs as heads of in charge of family land, stool land, skin land, and so on, as it were. So if we look at subsection 4, 13.4, it makes the point that a fiduciary under this section who contravenes subsection 2 commits an offense and is liable on summary conviction to a fine of not less than 5,000 penalty units and not more than 10,000 penalty units, or a term of imprisonment of not less than 5 years and not more than 10 years, or to both. So, for example, if you are asked to discuss some of the new things which have been added to the law, especially let's say customary land law and so on, this is a very important new development, meaning that now even the chiefs or the occupants of the skins, the stools and all that, who have like the responsibility to manage these stool lands and ski lands, they cannot do anything that they like, and they will be held accountable, and they can even go to prison. That is a very serious thing, isn't it? And that is a very serious thing. And that is why, and if you look at the subsection 5, it's applying the head of family accountability, PNDC 114 I mentioned. It shall apply with necessary modification. What that means is that if you look at PNDC law 114, a family member can go to court, and now there are 2 cases I've done in that respect, can go to court and ask the court to order the head of family to render account as it were. Somebody has asked a question. So what does it mean? And somebody is asking, is subsection 9. Please, subsection 9 of what? Subsection 9. Do you mean subsection 9 of section 10 that we're discussing? Yeah, I mean, if you mean that, of course, as far as the land legislation were concerned, we do not have any special provision in that respect. So in that respect, that is new. Then somebody is also asking the question, what does it mean to say 40% of the value of plots? of land being taken where a usufruct interest is interrupted for community interests? Is it 40% of the market value of the said land? Yeah, so you are referring to where they need to take over the land in respect of which the usufruct had an interest. If that is what you are referring to, then certainly, if they say like the 40% of the value of the plot, the 40% in my mind will be like the market value, that is the price at which a willing purchaser is prepared to buy that land at that particular point in time. Yeah, so I think you are right. Yeah, so I was making a point that if you look at the head of family accountability law, a member of a family or an individual could bring an action compelling the head of family to account. And according to the Land Act, that provision is supposed to be applied with necessary modification to a chief in respect of their management of a stool or skin land. So meaning that a member in the community, but in which the particular stool and stool land is, could request the chief to, for example, render an account for how many lands has been sold over the period, how much money has been made, what has he done with the money and all that. All those things can be done. And that is the kind of accountability that we are talking about. Of course, this is what the law is saying, but as whether practically that can be done is another thing, because if you drag your chief to court and you'll be able to stay in that community again, that one you don't come and tell me, you have to handle it yourself. So some of these laws, they're interesting, but as whether they will be implemented with that boldness and smoothness is another thing altogether. Good. Then with respect to disposition of land by allodial title holder, where the land is not registered. If you look at the old law, so all that, just in case you've forgotten, all that we are trying to do and discussing on Dennis' paper is that we are trying to look at how the new law has changed like the old law. And so that is what we are trying to do. We'll be taking like the thematic, like the eras. So another point we are trying to look at to see if there has been some changes or improvements by the new law is disposition of land by allodial title holder when the land is not registered. And previously, there was no policy on sale or disposition of this type of land, skin, stool, or family land. And there were no sanction if they dispose of them, especially when there's no evidence of registration concerning those land. And there were some problems with that because the allodial title holders will sell the land and it will eventually has negative repercussion on physical planning of the area. You know, you need to do physical planning and do proper, what do you call like the zoning, right? Town zoning, rezoning in terms of which area to use for which amenities, which area to use for that. Now, when the allodial title holders are selling the land because they've not been registered and they have not been processed in terms of physical planning, in terms of town zoning and all that, eventually that brought about litigation. In what respect? Because they are not, there's no registration, they are not properly surveyed, no planning. They sell them anyhow, and sometimes people will build houses in places which is supposed to be like a passage, like a street. And the place becomes so built up that there's even no place for you to live as streets and all that. And those who are minded will then go to court and try to get some demolition orders and all that. That is the that is the problem that we have. And to actually guard against some of this development, I think the section 182, right? Section 182, I think has come in to solve some of these problems. Section 182 is headed the registration of stool or skin or clan or family land. So let's look at that provision, section 182. Subject to this act and any other enactment, where land or interest in land is vested in stool or skin or clan or family, the stool or skin or clan or family shall be registered as proprietor of that land or interest. So meaning that there's going to be like a registration of the allodia in respect of all this land and all that. Subsection 2, an application for registration of allodia, which is evidenced by an instrument, shall not be processed unless there is attached to the instrument an approved plan of the land. So now it is mandatory for a land in respect of which allodia is held to be processed and then made to fit into an approved plan before it will be registered. So what is the procedure then? 1823, an allodia title holder who intends to register that title shall demarcate, survey, and prepare a plan of that land with approval of the Director of Survey and Mapping Division. So that will ensure some kind of like the control, because if you even get to a surveyor to survey the land in which you have that allodia, you want to get them registered so they can start selling them, you need to go to the Director of Mapping and Survey Division of Lands Commission to get approval, and he will ensure that it fits within like the general approved physical planning and all that before we will grant the approval. So these are some of the control measures. And if you look at the 182.4, that is even more pregnant in terms of what we are currently discussing. 182.4, that an allodia title holder shall not dispose of an interest in a portion of land held by the allodia title holder unless the whole land covered by the allodia title is registered. So this is very important, that if you're allodia title holder, you cannot sell, you cannot dispose of an interest in land without having not just the portion you want to sell. It's saying that unless the whole land covered by the allodia title. So let's say that if you are the allodia title of the whole of the land in, let's say, Amasaman, right? Or the whole of the land in, let's say, Ejoso, or the whole of the land in, let's say, somewhere in the Amfuaga, right? In Volta region. Let's say like the allodia title there. Now, according to section 182.4, if you would like to dispose of an interest in any portion of this land, you must get the entire land in Amfuaga, in which you have the allodia title, be registered before you can go ahead and sell any portion thereof. Otherwise, you've done something which is illegal and there will be consequences. So if you look at the 182.5, for the avoidance, and of course, let me also add that the question that I asked, that in what ways has customary land law interest been affected by Act 1036? This is another point that you need to add, because if you look at the incidents, right, the bundle of rights and obligation and privilege related to this incident, this certainly allodia title, you could do whatever that you like, but now that is not so. The law is saying that yes, you are the allodia title holder, but it doesn't mean that you can just decide to sell it or do any other thing without doing the required registration of the entire land in respect of which you hold the allodia. Yeah, so you must keep that in mind. Yeah, so please, I would like you to read the whole of that provision, and because of time, we cannot discuss everything here. Otherwise, you will never finish. And another development which we should keep in mind is also that if you look at the new law, that is Act 1036, another new development is what we call like the reservation of areas for common use. And this is very important. If you look at the reality in our communities, even places which have been reserved for water courses and then for common use are often released for developers when they bring huge money to the allodia title holders. So to curtail this practice and ensure sanity, that areas which are marked out for common use are actually preserved and not used for any other purpose. Now, if you look at in section 20, section 20, no, I think look at the section 19. That is the areas for common use. And 19A will tell us that a community may set aside or recognize one or more areas of land within the community for common use by members of the community. And then the boundaries of any land which have been recognized or set aside for common use shall be marked out in the manner determined by the community, including any manner that is customary among the person who will use that land, to enable those persons recognize and keep to those land and all that. And the community, if you look at the 19.4, the community shall prepare a management plan which may extend to cover the use and management of more than one area of common land. So meaning that now, if an area is reserved for common use, it is not just to be there so that the chief or the whoever the traditional leader is at his whims and caprices can dispose of it. No, they're supposed to be like a committee, right? And this is a new addition to. They're supposed to be like the committee which will actually manage the area which are reserved for common use. And that is what section 19, section 4 speak to. And if you look at the subsection 6, a person who is not a member of the community may, with the agreement of the community, use common land in accordance with the terms of the customary law and usage and the management plan applicable to that land. So if a place has been reserved as for common use and you are not a member of the community, we need to put it for some other usage. It must fit within the management plan, which those who are in charge of managing have actually approved and all that. And another thing we should also note is that if you look at the 7, that the basic rights and duties of members of community in respect of a common land include. So the common land, members of the community have some rights and obligations towards that. So we'll just go through subsection 7A to H and know some of the rights and privileges which are reserved for them. And the district assemblies are also supposed to make a bylaws which will govern the areas that have been established as for common uses. Again, another new development we have to pay attention to is the establishment of a customary land secretariat. This is a very good development. And if you look at the, I've asked you to already read the provision on the customary land management. So I'm not going to belabor that point. I've asked you to read section 13 to section 22. And then just before we wind up, prohibition of discriminatory practice. Prohibition of a discriminatory practice. That is another important, and just trying to incorporate the constitutional anti-discrimination provision in land transaction. So if you look at section 11, prohibition of discriminatory practice, a decision or practice in respect of land under customary tenure, whether the land is individually or communally held, shall be in accordance with the customs, tradition, and practices of the community concerned. But a decision or practice which discriminates on grounds of A, place of origin, ethnic origin, political opinions, color, gender, occupation, disability, or socio-economic status is void. But of course, the section 11 is attempt to incorporate Article 17 of the 1992 Constitution, which are the anti-discrimination clause, also in land transaction. But insofar as is going to be governed by customary law or customs and all that, there will be, if we allow to go, tolerable discrimination, because if the customary law, for example, say that if you are a stranger, you cannot be given certain things. That is what the customary traditions are saying. So let us take note of that. Another important development is that the land gas, the phenomenon of land gas has been included in our law, which is a very welcoming news. You know, like the land guard has been a very big thing as far as the land transactions are concerned. And if we look at the section 12, right? If we look at the section 12, for example, it addresses the problem of a land guard. So look at the section 12. So all that we have tried to do is just to actually draw your attention to some of the new developments as far as this law is concerned. And of course, disposal of stool and skin land, the things we have here are not very new, because some of them are in the old repealed legislation, as well as the Constitution itself, when it comes to administration of stool land revenue and all that, K2C7 and all that. So please look at all that. And okay, so just before we go, just before we finish the night, another interesting development is the restriction on transfer of land by spouse. If we look at the section 38, right? If you look at section 38, and in fact, I will also like you to think about the debate which has been going on in Parliament, as well as the further development of the Mensa and Mensa, right, type of legislation. Because I think those are matters that you can even come in an essay or something for you to express your view on some. I think Dinah, please go ahead. Dinah.
Okay, Doug, good evening.
Good evening, Dinah.
Doug, please, with the act, I wanted to ask whether, in case of a problem question, whether we are going to apply the act or we're going to base our discussion on the case laws that we've learned already. Thank you, Doug.
All right. Okay, thank you. Let me say that when it comes to problem-based question, please, problem-based question, you are supposed to apply the law as it is and not the law as it was. Now, in terms of like the old law and all that, if you have a problem-based question, first of all, you have to look at if there are dates, right? Dates in which the transaction took place. It may well be that the transaction took place under some of the old law, and those laws will still be relevant in resolving that problem. So that is one thing that we should note, because this law that we have, it came into first December 2020. So transactions, and if you look at it, that is why I refer you to the transitional provisions, right? If you look at the section 283, and transitional provision is very important if you take any legislation. If you look at like section 283, for example, it makes the point that an application pending before the Lands Commission before the coming to force of this act shall be processed by the Land Commission in accordance with this act. Look at that. Even if you have submitted application for registration before this law was passed, it is going to be dealt with according to this new law. And then let's look, and then the compulsory acquisition to which have been made under the State Lands Act, which has also been repealed, will continue to be governed by that one. So if maybe you are talking about some compensation issues and all that, you have regard to provisions of that repealed law. And that is why I said that despite the repeal of Act 25 or 125, the provision of that act shall apply to a compulsory acquisition of land which commenced before the coming into force of this act. So let's say that if you have a problem question relating to compulsory acquisition, I think just like, I don't know whether there was one problem if I gave it to you, you have to make sure that if the compulsory acquisition took place after 2020, then you have to go by the procedure in Act 1036. On the other hand, if it was before the coming to force of this act, then you have to still go by the repealed Act 125. So that is what I can say, Dinah.
Thank you, Doc.
My pleasure. Yeah, so just before we leave, I said that we have to also address our mind to spouse, like marriage, like restoration on transfer of land by a spouse. And I referred you to section 38. This has been one of the thorny issues. So if you look at the 38.3, right? Parties to a conveyance. For example, you look at the 38 subsection 3. In a conveyance for a valuable consideration of an interest in land that is jointly acquired during the marriage, the spouses shall be deemed to be parties to the conveyance unless a contrary intention is expressed in the conveyance. Now, what this provision means is that if you do any instrument seeking to transfer an interest in land which was acquired during the subsistence of the marriage, then the law is making a presumption that even if one person is signing, there's a presumption that both parties have actually approved it. And that is why I say that unless a contrary intention is expressed in the conveyance, unless you indicate that the other party, for example, has not approved, and for that matter, the one doing the conveyance is transferring his interest. Maybe you have 50-50 interest in it or something like that, as it were. And then if you look at the subsection 4, that where contrary to subsection 3, a conveyance is made to only one spouse, that spouse shall be presumed to be holding the land or interest in the land in trust for the spouses, unless a contrary intention is expressed in the conveyance. So it was the other way. Maybe you're going to buy a house or a land, and it is made in the name of the husband, or the section 38.4 is saying that the husband is holding it as a trustee for himself and also for like the wife, and vice versa. If it's only in the name of the wife, it's also the same way. So let's keep that in mind. I've seen that somebody's hand is up. We are almost done. Has there been another substantial advantage? Yes. Yes, the new authorities, and I'll put some of the decisions to you. Of course, you know, spousal property is a very sensitive area in our country. You know how Justice Detiba actually sought to bring the constitutional provision to bear. Because if you look at the Article 22 of the Constitution contemplates that Parliament will pass spousal property bill, law, and all that. And this bill has been drafted long ago and has been back and forth in Parliament because, of course, you have like the male dominance of Parliament, and some of them do not want to have a law which will, for example, protect interests of women and let them be more or less like on equal footing when it comes to properties or ownership claim and things like that. So that is the difficulty. But if you look at the provision that we quoted, that is the so the person who said whether there has been like the new cases after Mensa and Mensa. Yes, there have been new cases, but all of them try to redevelop like a Mensa and Mensa, trying to say that, okay, some authorities will say that Mensa said that properties which are acquired during subsistence of the marriage are presumed to be a joint matrimonial property. But some other authorities will come and say that it doesn't mean that that is automatic. And sometimes you need to look at the rare facts before you can come to such determination and all that. But if you look at the section 38.3 and 4 that you read, you notice that it is more or less an endorsement of the ratio dissidenda in Mensa and Mensa. Yeah. Okay, so I think that we are effectively done. I would like to take your questions. In terms of like the covenants, I mean, just read them, they are over there. And also there's also preference for use of alternative dispute resolution mechanism when it comes to grievances concerning land. And the other thing that I think we need to also mention before we go is what you call the electronic conveyancing. Although you are not doing conveyancing here, but at least if you are talking about like the new features, it is important for us to remember that the new law has also introduced what we call the electronic conveyancing. So if you look at the section 73, right? Section 73 makes the point that where in this act a transfer of land or interest in land is required to be made by a conveyance, that transfer is lawfully made if the transfer is an electronic conveyance. So meaning that electronic conveyance, that is a conveyance which is not just by just a paper, right? Which is maybe like the digita online and so on. It's also recognized as quite valid. And if you look at the section 74, the Land Commission is supposed to put in place the necessary information system with the capability to support electronic conveyance, meaning that we are gravitating towards a time in which you will be able to get the lease done without actually signing physical paper. You probably just put your electronic signature there or something like that, and that is it. So these are some of the very happy times, and that will definitely obviate problems like the lease got bent or there has been forgery and things like that. So this will mark the end of our general revision of the Land Acts, and I would like to take any questions that you have before I close the night. So if you want to ask a question or if you want to add anything, just put up your hand and then we will take it before we end, just about 2-3 minutes. Yes. And the issue of judges certificate, okay. Edie. Okay, Edie, just before Edie, you come, Fufu has asked a question. On the issue of the judge's certificate, it has been stated that where the interest is stated, it will be registered, and where it was not, it will be noted by the land register. What does it mean to say it shall be noted? Must the registrar take it back to court, or how will the land eventually be registered? Which provision, Fufu? Which provision are you referring to? Section number what? Fufu? What section are you referring to? Put it in the chat. Okay, so while waiting for Fufu to indicate her provision, let's Idi Muhayudin come in. Idi, your hand was up.
Hello, Doug.
Yes.
Hello, Doug. Yes. I want to know whether the new act has impacted on the compulsory acquisition of land, the regime on, and if so, what exactly? If you could just summarize that slide.
Okay, I think it has, and I remember telling you, I think I gave you provisions that you should read. I said that if you look at the section 2, if you look at section 239, right? Compulsory acquisition procedure, we say that compulsory acquisition by the state shall be in accordance with procedures provided in sections 240 to 249. But I suggested that I would even like you to go back and read section 233 because new things have been added to the law. Now, if you go to section 233, it, for example, give you instances, some of the public purposes. Because if you look at the Constitution, Article 20, all that it says is that where a land is required for public purpose and all that, there may be compulsory acquisition and all that. But we don't have instances of what amounts to the public purposes. Now, section 233. Or for example, give us example that if you need land for public purposes, like for road, highway, all that infrastructure and all that, these are given. And so the constitutional provisions have been enacted with some examples. So, and not only that, if you look at the section 238, it's very important provision that if you are going to do compulsory acquisition, first of all, if the compulsory acquisition, right, is being done at the instance of an intended user. If we say intended user, let's suppose that a particular institution or a particular body or whatever would like to have a particular land which is occupied by some people to be used for a project which satisfy the public purposes that we have seen. Now, before that will be done, the law requires that there must be an evidence of availability of funds for payment or compensation. So the Land Commission should be furnished with information by the particular intended user or public body, which is going to be beneficiary of the land, which is going to compulsorily acquire that. Yes, we have this money in place, which can be used to pay all the compensation that needs to be paid to those who are presently occupying the land and so on and so forth. So that is, I think, one development. And not just that, that the money should even be put in an escrow account, so that the money is lying there. So not until the money is ready, the compulsory acquisition is not going to start, because the lawmaker is trying to avoid a situation in which you do compulsory acquisition and those whose rights have been affected are going to wait for a long time before getting compensation. So we want the money for the compensation to be ready and sitting in an account as it were. And then apart from that, I think that we have like a more specificity regarding the compulsory acquisition process. And that is why we have to look at section 240 and then the preliminary investigation, which will have to be made before compulsory acquisition is done, section 241. And then the notice, which is supposed to be served on those who have interest in the land, which is going to be, or which has been earmarked for compulsory acquisition. You have to look at section 242. And then the fact that after the notice has been given to those whose land is going to be affected, there will be need for proper demarcation, survey, and then the entry on the register, the land register, or the deeds register as it were. And 244 requires that consultation should be held with stakeholders. So there has to be like the consultation, engagement, dialogue with those who are affected, as well as the community leaders. And so that is very important. And regulations, of course, are supposed to be made, which will govern how consultation should be held in respect of the intended compulsory acquisition. And after the consultation, the Land Commission is supposed to publish a report. And these are new things. This was not in the old law. Like before compulsory acquisition is done, there should be an extensive consultation, and the Lands Commission should actually prepare what you call like a report of consultation in respect of the proposed acquisition. This is a new development. And the report is supposed to be made available to the traditional authority of the area, as well as the district assembly, And again, the states may also withdraw from the intended compulsory acquisition by publishing notice of withdrawal, just as a served notice on other people that we are going to withdraw. So it is possible for the state to say that having had a consultation, having considered all that, we are no longer interested in going ahead with the compulsory acquisition. So we have withdrawn, and a notice is supposed to be published in that regard. And that is what section 247 required. And in terms of assessing compensation, amount of compensation to be paid to those who interest will be affected, the Land Commission is supposed to take information from the local planning authority with respect to the following matters. One, as to whether the scheduled land, if we say the scheduled land, when we're looking at the definition section, we said that the scheduled land is an area of land which has been earmarked to be compulsorily acquired by the state. Good. So whether the scheduled land is subject to any local plan under the Land Use and Spatial Planning Act. So that will need to be considered in trying to work out the compensation. And B, if there is a local plan, the land use indicated in the local plan for the schedule, environmental consideration, So all this information will be provided, and it will guide computation of the compensation. And when the acquisition eventually takes place, there's supposed to be publication of EI, that is a executive instrument to bring it to the attention of everyone. And if you look at the section 250, if a person makes a claim or has a claim or an interest in a land, which is a subject matter of executive instrument, like as having been compulsorily acquired, that person has 6 months from the date of the publication of the executive instrument to make submission in writing to the Lands Commission, giving particulars of the claim or interest he has in the land, the manner in which his claim or interest has been affected by the compulsory acquisition, and the amount of compensation he is claiming on basis, and the basis for the calculation for the compensation that is claiming. So I think all those things, for example, the amount of compensation claimed and the basis of the calculation of the compensation, I think is a refinement of like the old law. And who are those who are entitled to make submission in respect of compulsory acquisition? A holder of any of the following: allodial title, customary law freehold, common law freehold, statutory interest, leasehold interest, customary tenancy, or any other interest or right in relation to land. So these are the things that you should be reading in section 251, service of notice, and the notice of assessment and how the assessment is done, 253, and the payment. And if there are conflicting claims, if this person says that I should be given like the compensation because the land is mine, not that person, how is that managed? Section 254. And the basis of assessment compensation, so that is very important. And this is like, if you like it's a new development, how the compensation is done. It is more scientific now, and a lot of things are taken into account. So look at section 255, and then section 256, section 257, section 258. All these are matters which go into how to work out the compensation, more scientific, and how the payment of the compensation is actually made. Look at 259 and then the 260, and where there has been like the delay in respect of the payment of compensation, or where there has been an error, how those things are managed. And finally, resettlement of the displaced persons, where we need to resettle people whose land is being compulsorily acquired. And this is a new development. So look at section 265. So the one who asked the question, I think that these are very useful development. And finally, if you look at section 267, subsequent disposal of an acquired land, where a land has compulsorily been acquired, especially if you look at the fight which has been going on between the chiefs of Ga, like some of the Accra chiefs, right? The Ga traditional area chiefs and University of Ghana, and of course the government of Ghana in one way or the other, where they are complaining that, well, you compulsorily acquired lands, our stool lands, that you're going to use them for public purposes. You didn't use it, and then you have sold it to some other developers. We want our land back. Section 267 is an answer to that. So if you look at section 267, where land has been compulsorily acquired under this act or before the coming into force of this act, a subsequent disposal or use or dealing with the land, whether by the state or the person on whose behalf the land was acquired, shall not invalidate the acquisition of the land, except that the disposal or use of or dealing with the land shall be in accordance with provisions of Article 20 of the Constitution. And if you look at Article 20 of the Constitution, if you remember, it says that if the land is compulsorily acquired and you do not need it for the purpose for which it was acquired, you shall give what you call like the first option to the original person. That is the person who previously had the land. Look at Article 20, clause 6. Article 20, clause 6. Let me quote it. Where the property is not used in the public interest or the purpose for which it is acquired, the owner of the property immediately before the compulsory acquisition shall be given the first option for acquiring the property and shall, on such acquisition, refund the whole or part of the compensation paid to him as provided for by law or such other amount as is commensurate with the value of the property at the time of the reacquisition. Now, so that is what the Constitution says should be done in case you don't use the land and you need to dispose of. But remember the confusion the Supreme Court has introduced in this area of the law with the greatest respect, especially in the Okujetua Blackwell and then Obichebi-Lamte case, where they made the point that insofar as the land which was compulsorily acquired, which was not used for the original purpose, but is being used for some other public purpose, then you cannot say that it was not used. And for that matter, the provision that I just read, 26, should be triggered so as to say that the original owner is the one who has like the first option and so on and so forth. Yeah, so that is what I can say in respect of the question by, is it Diana? Oh, yeah, the student who asked that question. Okay, Eddie, I think Eddie, I don't know whether we have dealt with you. It's midnight now, and I think that my family will be angry with me, and your family will also be angry with you, especially those who have families. So I have to release you to go to bed. So thank you very much for coming and have a very good morning.